Holding charge. A lot of us might not be familiar with it, but this is a situation whereby the defendant is brought before a court, usually magistrate court, to secure a remand order pending investigation and legal advice from the Director of Public Prosecution at the Ministry of Justice. It has become a normal practice for police officers in Nigeria that whenever a person is suspected of having committed a capital offense of which the magistrate court lacks jurisdiction to entertain, that instead of them to assemble the file and forward it to the Ministry of Justice for a proper charge before a high court, that is a court with jurisdiction to entertain capital offenses, they would instead charge the person to magistrate courts, knowing that the matter cannot go on because of lack of jurisdiction on the basis of holding charge. Then the magistrate will then remand the person in prison. This places the defendant in a state of delusion and infringement on his fundamental rights to fair hearing as enshrined in the Constitution by virtue of Section 36 of the 1999 Constitution as amended. This practice is ridiculous and is unknown to our judicial system. Relying on the case of Ibegim and Commissioner of Police, Abia State, and another, the full citation, even the case, will be on the comment section in case if you're interested in reading it. This matter indeed has been settled in a number of cases, but let's use the case of Bola Kale versus the state as an example. The citation will be on this comment section, where the court held that it's an aberration, an abuse of judicial process for an accused person to be charged at the magistrate court for an offense of which the magistrate court lacks jurisdiction to entertain, only for the accused person to be remanded in prison custody without being tried or properly charged before a competent court for trial. It will be an infraction on the right to fair hearing and liberty of the accused person. It will place him in a position of hopelessness as to how to enforce his rights or defend himself. Also, in the case of Onagorora versus the state, the citation will also be on the comment section. Nekitobi said something that the police in this country rush to the courts on what they generally refer to as holding charge. Ever before they conduct investigations, though there is nothing known to the law as holding charge. He also went further to say that where the investigation does not succeed in assembling relevant evidences to prosecute the accused to secure conviction, that the best discretion is to abandon the matter and throw it in the toil. That on no account should it go out of its way in search of evidence to prosecute the accused when it is not there. When it degenerates to such a situation of hunting down, the prosecution is no more regarded as a prosecutor, but as a persecutor. And that is not consistent with the philosophy of our adversary system of adjudication. I believe you've listened to me up to this point and listened to the decisions of the court I've mentioned, even the one I read out. And you can now see there is nothing like holding charge. So those acts are unlawful and unconstitutional. Yes, it is good you're guided. Be informed. If you're watching me from Facebook, please follow my page, like, comment, and share. And if you're watching me from YouTube, please subscribe to my YouTube channel.